Will I be suppose?
Yes, Manjushri, you can go ahead. Well,
Good evening, everyone, and good afternoon, perhaps to Damien, who's joining us from Brussels. Welcome to this panel discussion titled "In Equipping Indian Competition Law to Face the Challenges Posed by Big Tech Companies." First of all, thank you, ADIF, for having me over to moderate this session with Amanat Kullar, who's also going to be my co-moderator through this session. My name is Manjushri. I am a senior resident fellow with the Vidhi Center for Legal Policy. I work with the Law and Technology team currently, but I've previously assisted the Ministry of Corporate Affairs in drafting the Competition Amendment Bill 2020. Now, this particular panel discussion is very well timed and opportune. And this is because we are looking at a situation where globally there is consensus where politicians, regulators, and all sorts of stakeholders are turning towards competition law to be able to effectively impose fair checks and balances on big tech companies. Now, this is a very interesting development, and with this really diverse and interesting set of panelists we have today, I'm sure we will be able to discuss what Indian competition law can do, what Indian competition law can become, and how Indian competition policy can be framed for a forward-looking approach to ensure that the digital economy, the digital market is free, contestable, and remains open to players of all sizes. So without further ado, I would like to hand this over to my co-moderator, Amanat, to introduce the panelists we have here today.
Thank you, Manjushri. So my name is Amanat Kullar. I oversee content and editorial at the Alliance of Digital India Foundation, and we're very glad to have all the panelists with us today. And thank you to everyone in the audience who have joined us. So today we are joined by an esteemed panel of experts who have been at the forefront of discussions around the challenges posed by big tech and around the regulation of their anti-competitive behavior. First of all, we have Dr. Amar Patnaik with us, who is a member of the parliament in Rajya Sabha representing the Biju Janata Dal. He's also the party's national spokesperson and head of the party's IT wing. Moreover, Mr. Dr. Patnaik is a member of the Parliamentary Standing Committee on Finance. Thank you so much for joining us today, Dr. Patnaik. Really appreciate you taking out the time.
Thank you so much. Namaskar.
Next, we have Soumya Singh Rathore with us. Soumya is a co-founder at Winzo, an interactive entertainment platform with over 80 million users. Soumya has a master's in consumer psychology and has previously worked with KPMG, the Times Group, and Zorooms. Thanks so much for joining us today, Soumya. We're very glad to have you on the panel.
Here. Thank you.
Thank you. Next, we have Damien Gerardin with us. Damien is the founding partner of Gerardin Partners. Over the past 2 decades, Damien has represented a wide variety of clients in multiple European Commission competition investigations, as well as investigations by the French, German, and UK competition authorities. He's joining us from Brussels today. Thank you so much for joining us, Damien.
Pleasure.
Next, we have Rajneesh Jaswal with us. Rajneesh has 2 decades of experience in various elements of law and business. At present, he acts as the General Counsel at Coup App, and he also leads the policy team and acts as the Chief Compliance Officer for Coup. Thanks for joining us today, Rajneesh. We're very glad to have you on the panel.
Thank you for having me.
Thanks. And last of all, we have Sijo Kurovilla George with us. Sijo is the Executive Director of the Alliance of Digital India Foundation. ADIF is an industry body for India's digital startups with an overarching aim of making the Indian startup ecosystem among the top in the world. Thanks for joining us today, Sijo.
Thanks, Amanat.
So first of all, due to some prior engagements, Dr. Patnaik would unfortunately not be able to stay for the entire discussion. So before we turn to the other panelists to share their remarks on the subject, I'd like to invite Dr. Patnaik to share his thoughts on the relevant policy interventions.
Thank you so much, Amanat, and thank you, ADIF. And my apologies to the co-panelists that I wouldn't be able to gain from their knowledge that they would be speaking about in the panel discussion subsequently, but I'll be there for about 20-25 minutes. And then maybe I'll probably still continue to hear on my mobile phone when I'm traveling to the other destination to attend the program. But this is very timely in the sense, as you would be aware, the Standing Committee on Finance has taken up this issue of the competition law and the antitrust activities of big tech companies. And incidentally, we have already had probably a couple of discussions on this front from various Indian stakeholders, Indian players who have been affected by the big tech. And we are also aware of the fact that the competition law in India, which was promulgated in 2002, has probably outlived its context. I would say outlived its context at that time, and it requires certain amendments or maybe even a newer form of the law. So given this particular background, I would compliment ADIF for organizing this webinar because it is very timely, very relevant, and very topical. My thought on this, which I have also aired elsewhere and also in the committee, is the fact that the basic, the crux of a competitive environment lies in frictionless flow of information between the buyers and sellers. And of course, there should be as many buyers as possible, as many sellers as possible, which is market development activity, but there should be frictionless flow of information, in which case the information is not, one particular group of people are not privy to some information. And the various other aspects of competition, fair competition, which we have studied in neoclassical economics. Now, if you take as the background, you would realize that most of our competition laws, not just in India, but even outside, are reactive in the sense there would be a complaint of anti-competitive practices against a player, and then the competition authority will be taking up that particular case for adjudication within the framework of the competition law existing at that point of time. But with the advent of digital technology, with the advent of the big tech, with the advent of blended products, with the advent of barriers between traditional markets breaking down or having already broken down, with the advent of cross-boundary transactions happening at the blink of an eye, and the big tech able to take full advantage of it because of the advancements in technology, because of the I'll come to dominance later, but because of the position that they enjoy in the market even to start with, the competition law needs to look at the entire rulemaking from an ex-ante kind of a situation. That is, how to ensure that the information flow between the buyers and the sellers is frictionless, as quickly as possible, as open as possible, as transparent as possible, and as qualitative as possible. Now, I think this is one area where the Indian competition law is definitely lacking because of the way we envision our competition law. So this is one challenge, I think, which is there before the Competition Commission or the new competition law that we would like to have in our country. And I hope this would be addressed. Then, of course, comes the issue of the usual issues of abuse of dominant position, and of course anti-competitive agreements, merger control, predatory pricing, blended products, surrogate advertisement. Now, many of these, you would realize, that has also come into the new Consumer Protection Act in 2020 and the rules that have been made thereunder. So, so while we are looking at competition commission, which is settling disputes between competitors, we have to also remember that we are doing all this for the consumer, and therefore the Consumer Protection Act and the Competition Act has to be seamlessly integrating into each other, and no player, including the big tech, should be able to take a regulatory advantage of one law against the other. And this is what is already happening because of some loopholes or some broad definitions that has been given in the current Competition Commission with regards to jurisdiction, where the big tech says that we are governed by the SEBI and we are not governed by the Competition Commission of India. Then, of course, is the issue of the abuse of dominance. Now, abuse of dominance would always be an issue in any market, in any competition law. The point is how quickly, how efficiently, and how promptly one is able to adjudicate on that. And the problem is to establish dominance. The investigation process that currently under process is currently prescribed is very lengthy and tedious. And that is what creates the problem. Besides, the big tech companies also look for loopholes within this statute to escape their liability, because Section 4 of the Competition Act has been drafted very broadly. So the interpretation of it probably is something which is left to the presiding officers and judges in the boards or in the constitutional courts. Now, this has to be tightly defined, because relevant markets may not adequately address the issue of digital markets. And I talked about the way they interface with each other, and the way we can have products which can use some of the advantages of a traditional market and some of the advantages of a digital market. And therefore, the law has to be more sharper as far as these aspects are concerned. Now, this is one challenge. The other one is the deal value. So something flowing from this is the deal value threshold. Currently, the deal value threshold, as I said, the context in which the competition law was framed in 2002 did not see the huge amount of internet-based activities. And therefore, the current definition needs to define this threshold by taking both into account. So this is something which is very important. This is something which might address the issue to some extent, but I can tell you this much, that the way technology is developing, the way newer disruptive technologies are coming in, the definition itself or these thresholds themselves will have to be discussed in great detail with all the people who are involved. And a conscious view has to be taken, because newer forms of breaching this particular threshold and not getting detected should not be adopted by the big tech, which is quite possible by using different kind of technologies, particularly, let us say, blockchain. I think these are the broad, I think, constraints that the current competition commission has. The number one, as I said, about ex-ante restrictions needs to be put, because currently they're mostly reactive. The number two is the definition of relevant markets. Number three is the threshold. And number four is the jurisdiction issue. And number five is the penalties. Now, I think the penalties, I would not comment really about the quantum of penalty, but I strongly believe that, like the personal data protection bill, which has not yet been passed, in which I was a member of that committee on Joint Parliamentary Committee on Personal Data Protection, where we have fixed this penalty. There are two kinds of penalties over there, which is the offense criminal penalty, and then there is the civil penalty. And the penalties have been pegged as a percentage of the revenues, gross revenue of international revenue, gross global revenue of the big tech. Because national revenues, I can tell you with certainty that even the people working for the big tech in India do not know what is the Indian revenue. The way they are structured, the way they recognize the revenue, the way they have structured their form, the way they have calculated the way they are calculating their revenue. This is very complex, and therefore I think while drafting the new law, this has to be taken into account. It should be graded. It should be recognizable, and it should be simpler, so that there are less amount of litigations. And I think the best is the global revenue as far as the big tech is concerned, and that is what has been followed even in the GDPR. The last point is about settlement and commitments. There, I think the mechanism is recommended for speedy resolution of cases. I think we have to encourage and promote that. Currently the number of cases that is there before the CCI are quite too large, too many, and I think this particular mechanism has to be promoted. Just as in the case of the Consumer Protection Act, mediation has been put in as a separate chapter, which was not there earlier and is being promoted aggressively it's one of the duty of the the Education Consumer Protection Advisory Committee to actually promote that particular kind of that line of settlement of consumer disputes as well. So I think broadly, for 800 million internet users and growing, and all kinds of takeovers, mergers, acquisitions taking place, this is very important that the Competition Commission law of India has to undergo some very crucial changes, amendments. I'm happy to inform that this is already in the offing. It was listed for introduction in the last session, but I think it didn't get introduced. Will probably get introduced in the coming session. This has been under discussion in the Finance Committee, and in the Finance Committee discussions, since the details of which obviously I can't share in great granularity because of confidentiality issues. But what I can of course say is the predatory pricing. The predatory pricing is a big issue, how the competition law would address that, because of the fact that some of those products are, as I said, blended products. So you do not have such kind of products in the market. You do not have such kind of products in the traditional market. And if a traditional market player wants to develop such kind of products, he doesn't have the infrastructural support in terms of public infrastructural, free infrastructural support to achieve that. For that, it has to make initial investments, which it cannot obviously make, and therefore it is at a disadvantage. Having said all this, one must also realize the fact that while drafting this law, it should not be seen as something which is anti-merger acquisition, anti-innovation, anti-this. It has to promote both. It is very important that it should not kill competition. It is only to make competition fairer, make competition on a level playing field for both domestic and international players, and should actually be ultimately to the benefit of consumers. I think that is the key, because consumer is the king. So the seamless integration or consultation between the Ministry of Consumer Affairs and the Ministry of Corporate Affairs, which is the administrative ministry for the CCI, and which will be promoting this particular amendments, I think that particular consultation is necessary. We in the Finance Committee are ensuring that that happens. So thank you so much. I think these are my thoughts on this, and I have been a great supporter of the fact that instead of punitive measures, if we can actually develop the market by giving guidance and education and awareness, a lot of things can also be addressed. And therefore, my thrust on ex-ante restrictions and free flow of information, which is applicable to big tech as well, as to what is their operation, what they are doing. Many of it probably would get addressed in the data privacy law or in some other kind of laws which is there from the IT sector. But I think if they're targeting a consumer, the kind of information that they are giving to him and the kind of information that they're collecting from him, both are important. Thank you so much.
Thank you, Dr. Patnaik. That was a very comprehensive and informative overview on all of the issues that Indian competition law perhaps must tackle in the way ahead. As you rightly said, we have a very reactive way of approaching competition problems and not really a preventive way of doing that. And probably through ex-ante approach, we will focus more on prevention so that this does not reach this CCI in the first place to begin with, and we can avoid lengthy investigations once and for all. If, with your permission, Dr. Patnaik, we will open the floor now to the rest of the panelists for a question-answer session. We will try and divide this into 3 sessions. First, we will try and understand what are the pressing competition issues that one faces while dealing with startups. And specifically, given that we have many startup founders on the panel, they will be able to tell us, perhaps, and educate us as to what are their points of interaction with big tech companies, for better or worse. And second, we will go on to looking at what are the key international developments in being able to tackle big tech companies, what is it that is happening globally, and what can India learn from these experiences. And third, if time remains, we will definitely open the floor up to our participants for any questions that they may have. And we have received a few questions during the registration process too. And if time permits, we will take those up. My first question, taking from this, is to Sijo. Sijo, we understand that that you were one of the stakeholders that consulted or made representations before the Parliamentary Committee on Finance in terms of understanding what practices that are particularly anti-competitive, or what is it that you as an alliance feel is particularly anti-competitive when it comes to the behavior of big tech companies. So what is it that you briefed the committee on, Sijo, if I may ask, and what are the particular points of interactions that you have faced with big tech companies that makes you go like, oh, wait, this must be anti-competitive. This shouldn't be allowed under the law, but they are getting away with it nonetheless. What are some of those practices that you have seen in your experience?
Thanks, Manjushree. So without going into the very specifics of the committee deliberations, I would probably talk in broader terms, how we and what all we observed and how we came to this particular representation as well.
Yeah.
So with ADIF, one of the issues that we had witnessed, and over the course of the last year and a half, we have been actually witnessing way more issues. In fact, Samya Windsor has taken up issues, who is also reaching out. And one of the issues where we had taken up was the objection to the App Store fee, the Google Lagan, so to speak, right? And to answer your question, I think, Manjushree, you made the question very simple, right? And in the sense that Sunte, we sort of feel that this doesn't seem fair, right? And that's straightforward, that someone who's actually selling on the App Store has to mandatorily use only the billing system that is provided by these platforms, which by itself is a different market, so to speak, right? And they're also charging a commission, which is significantly high, which is what every participant has felt. Now, fair enough, from a price standpoint, yes, every market participant is free to price their services depending on the innovation or the potential. But it should be an open and fair competition where other players also has to participate, in which price discovery can happen, right? This was a broader problem in which we started interacting, and we had reached out to CCI in terms of filing a petition on the issue and actually seeking relief also, right? So while there was an investigation by CCI into the specific matter, we were still seeing Google making changes to their policy, and probably the deadline was approaching, and all developers were getting very anxious. And from a classic language, from taking a leaf from the legal language, irreparable harm was actually in the offing, right? So we had to have some sort of interim relief, right? CCI was doing a commendable work, and CCI needed to have all the time and support that they required to complete the investigation. But before that, if this policy implementation happens, a lot of our Indian developers would have even ran out of business.
Yeah.
Just for the on top of the margins that they make. But if I were to broad base the problem, right, while we started working on this, we started seeing similar behaviors across other markets as well. If I take the Google example itself, we could see almost a similar playbook happening in the Chrome browser space, right? They were using the Chrome browser dominance to extend their dominance into the mobile advertising space. They were looking at, taking out cookies and replacing with the proprietary, technology. And we could see this in across markets, right? And if I take the app example also, this 30% commission on the Google Lagan, that mandatory implementation of billing policy, is just one part of the problem. If you look at the larger set of issues that developers are facing, right, there is a host of problems, right from delisting, deplatforming, including shadow deplatforming. Hardly any notice. 2 days back, we had India Gold founder Deepak Abad crying out foul, saying that not even notice was given even before these platforms are taken out. One of the flashpoints that happened in India where a lot of attention got into it was when Paytm app was taken out of the store, right? We are seeing other behaviors like self-preferencing, where platforms, apps are given more precedence. So there was a host of issues. And this is the reason why we sort of wrote our representation to the Parliamentary Standing Committee on Finance also. And by and large, pretty much some of the points were broadly covered by Dr. Patnaik in his opening address itself. The root of our argument or root of our representation was that this process of Competition Commission of India was not really, either the CCI is not really equipped to rein in some of the practices by these big techs, or it's not progressing at a fast enough pace that is more suited to digital markets, right? And what needs to be done? So yes, one of the best takeaways from the interaction with the Parliamentary Standing Committee was the fact that all the committee members were significantly aware of the challenges faced by businesses. Right. If you look at even commendable work on the part of CCI, right? CCI has taken various initiatives to make sure that these cases are brought in. So CCI has taken more liberal view in terms of definition of market so that these issues could be addressed. We recently read about CCI even creating a digital markets unit to add capacity. So in the larger framework, there definitely needs to be a rethink of how we even look at some of these competition law. And if I were to just make one point, just to double click on what Dr. Patnaik already mentioned, it's mostly in the lens of viewing ex-ante legislations. So currently, almost every intervention by the competition regulator happens ex post. And then typically we have seen a 12 to 24 month, in the best case scenarios, timeline before they're intervening and finally come out with a verdict. Even in such a scenario, these verdicts tend to be challenged by these companies in the higher courts, right? And if you look at the incident that I mentioned, a small change in policy could probably reopen the whole investigation process all over again. So it's actually very time-consuming and cumbersome. We also see a significant behavior, and I'm sure our counterparts from across the globe are also seeing the same significant behavior, where even in the instance of a verdict, some of these companies are proceeding by continuously paying the fine and not complying to even the guidelines. They're sort of treating as cost of doing business as well, which is not a great situation for any market, so to speak, to be at. Yeah. So these are broadly the points we wanted to convey. Our representation spoke a lot more specifically on the app market issue, since that was one of the issues that we're working. But we did make a subsequent representation on the larger platform issues and the thinking what we have on the same matter. It's also great and commendable that the committee already was appraised of the matter, and the fact that they do realize that a rethink of the computational architecture itself is probably required to better protect the markets and Indian companies.
Thank you, Sujal. So you very rightly sort of summarized that the market needs to be open and fair, where price discovery can happen. Next, I would like to turn to Damien. Damien, among the concerns that Siju has highlighted, right? So, for example, the use of dominance in one sector, so to make businesses in another sector, or for example, the penalties that are imposed on big tech, they are now built into their business models. They have become the cost of doing business. Do you find any similar concerns in the EU?
Yes, absolutely. First of all, it's important to note that these companies we're talking about are global in nature, and typically they apply the same business model everywhere. So if you think about the Apple App Store or the Google Play Store, well, they're not different, right? I mean, it's the same in India as it would be in the European Union. And so it's no surprise that we're facing the same difficulties. So, I think there is someone on the phone. Yeah, that's better. Yeah, so we're seeing exactly the same problems in the European Union. And if you're thinking about the App Store, well, it's also about the imposition of, the platform's in-app payment solution that has been identified as a difficulty. The 30% commission is also problematic. And we are also facing issues of non-compliance. Let me give you an example. I was involved in a case against Apple in the Netherlands, where the Dutch Competition Authority found that it was an abuse of a dominant position for Apple to impose its in-app payment solution on app developers, right? And so this part of the decision was sustained by the court. And from the 15th of January of this year, Apple had to comply. Well, they did not comply, preferring instead to pay a fine of 5 million euros per week of non-compliance. And they did that for 10 weeks. Then for another 10 weeks, they had discussions with the Dutch Competition Authority. Finally, after almost half a year, they decided to take steps to comply, but they comply in a way that is not very helpful. So it means that even when you have a decision of a competition authority or a court, it's not a given that they will comply, right? And I think we're seeing increased examples of non-compliance. By the way, App Store issues have also been looked at in Korea, with legislation decided to tackle these problems. But once again, Apple and Google are not complying. And it's going to take a long time, I think, to bring them on board. Other jurisdictions are also looking in these matters. Apple and Google are investigated by the CMA in the UK for App Store issues, right? The ACCC in Australia is also looking at the matter. In the United States, you've got various pieces of litigation involving Apple in Epic Games. So these issues are not, Indian or European issues, they're global issues, and increasingly competition authorities and legislative bodies are aware of these problems and taking steps to tackle them.
Thanks, Damien. Sort of the example that you used of Netherlands, where Apple has consistently chosen to pay fines, and fines up to 5 million euros every week rather than comply for the longest time. Sort of, it's like a slap on their wrist, right? So it's becoming very clear that these penalties after the fact don't really work. So thanks for using that example. That sort of summarizes
That's exactly true. And, you're talking about companies that have, 50 or 75 or 100 billion in cash. They have so much money that sometimes the only thing they do with the cash is to buy back their shares. So, 100 million here, 10 million there, it makes no difference whatsoever to them. Financial penalties don't work.
Correct. Thanks for that. So far we have talked about what are the different kind of anti-competitive practices, right? Like bundling, imposing of fees, mandating their own payment systems, like Apple and Google mandate their own payment systems. Now I would like to turn to first Soumya and then Rajneesh to give us some perspective on how these anti-competitive practices actually impact their businesses on the ground. So how do these practices impact you at Windsor, Soumya?
Thanks for that question, Amanat. And I'm just amazed how beautifully, Sijo had actually summarized some of the real problems that we live with as, game developers, gaming companies, startups on a daily basis. So, we are second-time entrepreneurs. So this is our second venture for both me and my co-founder, Pawan. We are the same team from Zorooms and Zostel days. And when we started back in 2018, we were very much on the Play Store. We looked at the Indian gaming sector, and we felt that it was fairly fragmented. There was lack of a culturally relevant product. There weren't many studios that were making for India. They almost became back offices to global gaming companies, and we just wondered why. We actually got our answers when we did business in that sector for 6 months, because it's absolutely unviable ecosystem, with India being 95% Android market. Your Android system belongs to the same player who holds the Google Play Store, belongs to the same player who holds the Chrome. So what essentially happens is that you either say, hey, you take my 30% and let's see what we can do with the rest of the money, survive or not. Or you kind of take your product completely off Play Store, which is a very different ballgame altogether. So we were very much on the Play Store, and one fine day, we got delisted randomly, and then it happened again, and we said that, okay, so what are we building for? We're going to completely lose the sight of the end user if we always have to drive the company around policies, which will kind of, we'll lose sight. So we are building Netflix of gaming. We are tying up with national, international game developers, getting their games on our platform, anchored on various formats that we are innovating within the company with microtransaction enabled ecosystem. We were just 1 million downloads then, and we said this is not viable. We'll have to take this ecosystem completely off the Play Store so that we have better margins, so that we can think about the end consumer when we are solving for the product, and so that we can run business in a sustainable way. Today, we are 80 million registered users present in 12 languages, tied up with 100 plus game developers in India, internationally, distributing off the Play Store. Can every player do that? The answer to that is no, because distributing off Play Store is a completely different ballgame altogether, where you're paying at least 5x more for every single user that you are acquiring. And then you need to figure out whether your business model, your revenue model can actually sustain that hit. For us, we decided to go through micro influencers, through a very, very different distribution model, and we could sustain that because we also had a very different monetization model, which was not same as in-app purchases. And then we started partnering with the game developers globally in India to get there, to create a parallel of Play Store, which does not operate on a 30% commission basis. However, when we do that, we also come across many contractual restrictions that players who are listing the product on Play Store can actually go through, where for them to actually get alternative revenues, distribute through any other channel can be very, very restrictive. And when we looked at that entire ecosystem, we said that, hey, there are 400 million people in India who are looking for content, gaming content, culturally relevant content. There's so much of talent, there's so much of consumption that's happening in India. Largest number of engagement hours in gaming today is clocked from India. We are looking at a sector, 1 in a million years opportunity. We can really build from Bharat for the rest of the world. But how will we do that if none of these companies actually sustain the first 18 months? Because there is no way you can actually make revenue, pay off salaries, even dream of profitability. So with this kind of an ecosystem that cuts you from across every single place, cuts your opportunities, and that's been our experience, really, kind of building in specifically the gaming ecosystem, which can get very, very challenging. We were fortunate to take an early decision. Rather, we had VC capital, etc., that came in, that gave us the runway and to take some bold calls rather. But I don't think that every developer in this country has access to that kind of an early capital, and that kind of kills innovation, kills early ideas, and kills the possibility, because you're now supposed to think within a very, very boxed ecosystem, completely losing the sight of the end consumer. That's been our experience. Thanks for kind of asking that question and giving me the opportunity to share with the rest of the ecosystem the challenges that we faced.
Thanks for sharing your experience, Soumya. May I ask, how many users were you at when you decided to move out of the Play Store ecosystem?
Yeah, we were 1 million, and
okay.
I still remember we were rated 4.8 by our users across some 40,000 reviews. And at that time in my life, I thought that it's one of the biggest loss, but I think that was one of the best turning points for the company to actually be pushed in that direction and build value. Today we are 80 million. So of course it came at a very, very expensive cost when compared to maybe a Play Store kind of ecosystem that had much more eyeballs and footfall. So
sure, but that's an excellent example for the Indus Valley ecosystem that you're setting. So thank you for that.
Thank you.
Thanks. Next, I would like to move to Rajneesh. So Rajneesh, in your work, can you talk about how KOO has been impacted by the policy, anti-competitive policies that we're talking about?
Yep. Thank you, Soumya, for, it presents some form of vision for us as well to what to look out for. I guess all of you know that Ku is India's only microblogging platform. It's India's answer to some of the bigger tech platforms out there doing microblogging and social media. Sometimes you wonder whether you want to be competitors with them. Are the people who are providing us with the tech and everything else, should they also be your competitors? But that's a much bigger question. I think for us, it's still early days. A lot of what I can say is similar to what Soumya expressed. We don't get hit by high commissions as yet. We are still a young company, but I think the interaction between the platform policies and then the local law is one of our biggest sort of issues. For example, all platforms have their policies and their community guidelines and how you should behave and how you should not behave. That's on one side. On the other side, we are in the social media space, and we have our own set of Indian laws, the intermediary guidelines. Do they comply with the Play Store policies? Maybe, maybe not. And then we are stuck in a hard place because we are asked to comply with the Play Store policies, which is not what is required by Indian law and things like that. Then again, Play Store policies themselves, they run into volumes and several versions. So I think just navigating through all of them, and as I said earlier, sometimes there are service providers, sometimes they are our competitors, sometimes we rely on them for very critical inputs. And then you're running from one part of the company to another. And I think, managing different parts of the same beast. So yeah, I mean, these are some of the very sort of top level issues. Do you comply with local law? Do you comply with platform policy? Do you treat them as a competitor? Do you treat them as an ally? If there is a conflict between your policy and their policy, what do you do next? Do you run the risk of deplatforming? Are they asking you to work in a certain way, which may or may not work for you, but it works for them certainly? And then, just the whole process of getting a notification on a day saying that XYZ steps will, coercive steps will be taken. And then I think this also comes from the fact that these are big, large global organizations. They have standard policies and they forget the local nuances. And when they forget or probably overlook the local nuances, or their interpretations are not very great, you sort of are running around trying to say, no, I am in compliance with local law, but may not be in your community guidelines. But shouldn't your community guidelines also comply with local law as well? So very real life challenges where you run the risk of your business almost coming to a standstill. Yeah.
Thank you for that, Rajneesh, and thank you so much, Soumya. I think, as you both rightly pointed out, as lawyers, we barely get an understanding from how this really impacts, startups and businesses at a very grassroots level. And this was an excellent explanation of what one needs to even look out for in terms of policy making. Sijo, I come back to you again. My next question was going to be, is India's competition law enough to tackle this? But I think we've sufficiently established that it is not. So you were talking about the petition that ADIF sort of tried to approach the CCI with in terms of the app store economy and the like. So drawing from your experiences, if I may ask you, what are particular places that you think could be more efficient to prevent the kind of delays we speak about? What is it that you faced in terms of what remedies did you think could have been, given out so that the market didn't irreversibly tip, as you were talking about? Or, what other sources of investigations, like a summary investigation, if that's something, that's in your mind. So from your experience, what do you think would have been bettered, not at the legislative side, but mostly in the enforcement side to sort of speed this whole process up? Because, as far as I see it, however much we try and be preventive with legislation, there is going to be a fair amount of litigation that is going to result from any sort of legislation. So if you're trying to particularly remedy that piece and make it more efficient, what is it that you would suggest be done in terms of priority?
Sure. So in terms of setting the context to answer this question, right? These are not just challenges limited to competition law in India. I mean, yeah. I'd like to build on to what Damien also said, right? Yeah. We are seeing these problems across the globe, right? And we're also learning along the way. Yeah. This behavior that, even in the instance of competition watchdog stepping in and even coming up with a verdict, right? Some of these companies are not complying is a behavior that we are blatantly seeing over the last year or so. I mean, 6 months or 8 months, so to speak, right? So I'm sure there have been other instances, but very specific to companies as well. And this is across the globe on the same issue itself. There's Netherlands issue, there is actually South Korea issue. And if I were to build on what Damien said, right? I mean, Damien, pleasure to meet you. I was not aware that you're the one who represented that particular instance. In fact, one of the questions by the parliamentary committee was exactly that. Are there instances where these companies, in spite of a verdict, are not complying? In fact, we had to highlight the Netherlands case as a case in point, where even such instances are not happening. But this is the context with which you're looking at, right? So we're also learning, and that's what Dr. Amar Patnaik also mentioned. Even while we're looking at even a legislative overhaul, we have to really put our heads and brains together as to what kind of responses or what kind of loopholes would be coming in, right? And that is, I think, the more, the opportunity and a challenge, right? And that's something the world has to really solve. From that standpoint, if I were to speak a bit from our experience, right? Let's say, yes, you're right when you say that there will be some amount of litigation that's happening at a point of, let's say, any legislative reform as well. Now, if I take 2 points, one is the instance that in our current case that we're pursuing with Competition Commission of India on the Google Lagan issue, you might be actually interested and surprised with the fact that ever since we filed the interim relief petition in October, right? CCI has been, proactive in terms of trying to get a interim relief petition hearing also done. Till date, and I'm saying till date, Google has not even submitted a response to our interim relief petition, right? They have been making requests for extensions, and each time the extension request is either accepted or denied by CCI. There has to be a limit to extensions, right? So CCI did provide extension. When even that extension is denied, we are seeing an instance where writ petition is filed with the high courts on the denial of extension even. So now we are even talking about a situation, not even the final verdict is challenged, right? Even the routine administrative orders are sort of being challenged. And this is a very interesting behavior that, and it's been going on. I just happened to hear, I'll have to go and confirm, that today also another writ petition was filed. So between December and right now, I think we have 3 writ petitions that have been filed on the very same matter without Google have even given a single response to the comment on the petition, right? So how do we sort of address this particular problem is also another hat we need to wear, Manjushri. I mean, we do understand that in a legislative environment, people have a right to appeal, right? We also need to have, and in this particular scenario, right, sometime in March, CCI also came out with their initial DG findings saying that it is anti-competitive, right? So if we take that simple principle and apply to the fact that these digital markets also move very fast, right? There is a deadline that was extended to March and the upcoming deadline is October. Developers were concerned in January whether we'll have to switch to something. We are still 3 months away, right? Now, Competition Commission of India has the authority within their statutes to actually issue interim relief. Now, fair enough, while this hearing is happening, if there is a challenge, it's understandable that until the final debate settles, they have the right to appeal for it. But in the interim, if there's an interim relief that was provided by the CCI, right? And the CCI hand is also equipped, as you rightly said. In so legislative, the enforcement is strengthened in terms of providing interim reliefs, right? Which might require legislative intervention for them to act much more strongly. That would have really saved all our nervous energies, right? So currently, then they are on the clock. So with each passing day, and I mean sort of put a number to there, right? With each passing day, when they get away with implementing the policy, they're clocking a few more millions or billions into the bank account, right? And the anxieties and the nervous energies of the developers in terms of what choices do I make goes out. And we should never forget the larger picture also, right? It's not about only the commissions and everything. Every company thrives on competitive advantage. And that is the reason why Soumya made that choice of moving away from that particular store and adopting an entirely different thing. It's not only about the commissions.
Yeah.
It's about access to data. It's when these companies have competing products, right? And Soumya, if I were to speak on your behalf, see, one of the specific instances which Soumya probably didn't mention is the fact that if you try to install an app on Android from outside the store, there'll be a pop-up that's saying that, hey, you seem to be installing a malicious sort of device. And that's possible by Google or even an Apple, because Apple does not even allow site loading. It's because of the end-to-end tech stack that they sort of control, And if I were to build on what Rajneesh also mentioned, right? I think one of the bigger challenges is that, yes, there are these discrepancies in terms of, let's say, their community standards, what's being adopted and what's the laws in the country. But if I were to add one more contour to it, even with the community standards that seem to claim that they are published, the arbitrariness or the high-handedness in which these community standards are enforced, right? That itself is a debate or a discussion topic in itself. There is, in most instances, there are hardly any notice. Rajneesh, from what I heard, you have a different problem every day. You have a notification, but there are instances where there are hardly any notice and there's no justifications given. We had a very recent incident when an app was delisted, citing a particular cause, which was the cause was also provided ex post. I mean, it's not even that they were provided notice. They fixed it and they intimated the authority saying that this has been fixed. The response was that, yes, everything is fine. It's still going to take 7 to 14 days for the app to be back on the store. This doesn't make any sense. 7 to 14 days is a significant amount of time. And while currently we can only talk about correlation or coincidence, most instances we see this happening to either companies who have competing interests with them or companies who are sort of looking at taking on some of these challenges with authorities. So currently we don't have specific correlated data to say that this is happening exactly in the particular manner, but the patterns are sort of very conspicuous not to start making that correlation. So these are some of the ways in which we should look at it. And I would also probably build on what Damien also said, right? Fines doesn't seem to be the answer or solution.
Yeah.
And that's why this debate is also great to learn from everybody.
Thank you, Sujo. And to Damien, if I can sort of ask you a follow-up from what Sujo just pointed out. There has been a history of competition proceedings getting delayed worldwide. Google, the shopping case, for instance, went on for a good 7 years, and then there was a record 2 billion fine. But what we seem to see from that is that the fine is almost always built into the costing of the company, in that it's easier for them to delay the proceedings and push it as opposed to appear for the proceedings and end it and not have a fine. It's in fact easier for them to pay a fine while still reaping the benefits of an unregulated environment at that point in time. So I guess what we're seeing is a situation where the burden of proof, in terms of, it might be crucial for us to understand the role that burden of proof plays here, because, if it is on the petitioner or if it is on the company making the claim, and it's usually a smaller company that's taking on a giant like a big tech, and if it's up to them to really demonstrate that there is in fact anti-competitive harm that's occurred, it is going to be a lengthy exercise. And some of the international developments that have been following have been talking about shifting this burden of proof, so that if there are certain practices that come to the light of the regulator, it is honestly up to the big tech company to justify that it didn't happen or it is not anti-competitive. What do you think is the merit of such an approach, especially when we're looking at time-bound investigations or investigations that need to strictly adhere to a smaller schedule to ensure that the market doesn't irreversibly dip?
Yeah, so I mean, lots of good topics and good questions in your intervention. I mean, first of all, I should say that the decisions of the Commission in the big tech space have not been particularly successful, for several reasons. First of all, it took them forever to adopt these decisions. Very often, 7 to 8 years.
Yeah.
In the platform space, this is 1 or 2 generations or 3 generations of product development. So very often, by the time the decision is formally adopted, the market has moved on.
Yeah.
Right? And the reason why it takes a lot of time is because it's a complex exercise. As you suggested, you need to define the market, identify a dominant position, come up with a theory of arms that will survive judicial scrutiny, and then you have to show effects. So it's a lot of work. And also there is an asymmetry of forces between the complainant and even the Commission and the defendants, which will throw infinite resources to their cases because they've got a lot of money. So what can you do about it? That's the question. Well, I think that First of all, one answer, and we'll talk about it later, is ex ante regulation, because it allows to circumvent some of the complications that come with competition law, and you can move faster, which is definitely a good thing. But also, I think that you still need to improve competition law, because not everything will be solved by ex ante regulation, right? I mean, there will always be practices that are novel, and there's always a distance between the moment you regulate and the practices that create harm. So I think you can do several things. I mean, first of all, I think that you need to streamline processes. Right? I think that many of these cases are really bloated. And in Europe, for example, we have very strict deadlines for merger control, but we have no deadlines for antitrust cases. So, you know, there's never any pressure for the competition authority to move forward because they're not subject to any statutory deadline. So that's something you could think about. The second thing you can think about is indeed to shift the burden of proof. And I think that you could think about it, especially when you face a gatekeeper, right? Really an operator that has very significant market power when there are no alternatives. And I mean, of course, if you think about the app stores on iOS and Android devices, this is one good example. You always have to be a little bit careful about shifting the burden of proof, because it could go against some basic principles of law. So it's definitely a good idea, but you want to maintain some due process, of course. And then finally, one of the weaknesses of competition decision is that the remedies are not effective. And several reasons for that. One is that they're not restorative. So what do you mean about restorative remedies? Well, very often the outcome of a competition decision is a cease and desist. So you've been, you know, harming rivals and consumers for 10 years, and then the outcome is you should stop. Yes, but no, because the market has been destroyed. So a restorative remedy is a remedy that will, you know, return the market to the status quo ante, or, you know, basically create a handicap for the firm that has been sanctioned so that others can sort of come back, right? So that's one idea, restorative remedies. And you know, I don't know why, but in the European Union, we've got a very poor record on remedies, very, very poor. They never function. So that's definitely something that needs to be thought about. How do you, you know, come up with meaningful remedies that really restore competition in the market? That's, in my view, a critical aspect.
Thank you.
Thank you. Go ahead.
Thank you so much, Damien. Just a follow-up question. I was going to come to it later, but maybe we should bring this up because it's an opportune moment. Given that we're talking about ex-ante regulation in Europe and, you know, in multiple other places, and the large reason why we're thinking of ex-ante regulation is precisely for this, in that remedies aren't always able to restore the health of the market, in that you're never really able to give competitors their place back in the market, and they often end up leaving. So, you know, you're probably not doing much for competitors. But do you think ex-ante regulation will help remedy that? Because the way I look at it is that even if there is something that's preventable, and if you say that that's outrightly wrong, for you to be able to justify why that's wrong might still be a complex, lengthy proceeding, and the market might tip in the meanwhile. So how do we really reconcile this? How do we make ex-ante regulation all the more effective in terms of being able to help out competitors in the run?
So, there are different models. The most famous model is probably the Digital Markets Act in the European Union, which will be voted today in Parliament, right? So today is the D-Day, but there's no question it will be adopted. Everybody's sort of in favor of it. And already the Commission is working on implementation. Okay. Well, the way it works is is that the Commission will designate so-called gatekeepers. There will be 5 to 7 or 8 companies that will be identified as gatekeepers, and you can already think about those, probably the GAFAM, as we call them, Google, Facebook, Microsoft, Amazon, and Apple, plus maybe a couple of others. And then there are a list of obligations, about 20 plus obligations that will apply just to them.
Yeah.
Right. So the focus is really on the gatekeepers, which is a good idea, because then you can really target those that need to be regulated. And these obligations are very concrete, right? So no tying, you have to allow in-app payment solutions of the choice of the app developers, and so on and so forth. So that is quite effective, because if you've got a problem, you can go to the Commission and say, I've got this problem with this company. And if the behavior falls under the list of obligation or prohibitions, depending the way they're formulated, that's it. There is an infringement. No need to define the market, show dominance, come up with a theory of harm and prove anti-competitive effect. The infringement is automatic, right? I think, of course, that it will not be as simple as that, because these companies will resist.
Yeah.
And, there will be probably litigation and everything, but it's really designed to streamline the process and avoid spending 8 years arguing about effects and these sort of things. So that's the model. And they're very strong sanctions. In case of repeated infringement, it can be up to 20% of the global turnover of a company. So you're talking about potentially a lot of money.
Yeah.
Another model is the UK model, which is not been adopted yet. The UK government is a bit late on the so-called DMU regime. There, they will identify companies with significant market status, right? It will likely be the same companies as those falling under the DMA. And for these companies, the digital market unit in the CMA will design codes of conduct, okay? So there will be a code of conduct for Apple, one for Google, one for Facebook, and so on and so forth. The advantage is that it may be a little bit more flexible, but the disadvantage is that it's coming late in the process, whereas the DMA is already there. So these are these models, and personally, I've worked a lot on lobbying for the DMA and explaining why it's beneficial, and I've really hoped. One thing that I would add, that will be my final word on this, is that what is critical, and it's been a problem in competition law, and it could be a problem with the DMA, it's human resources, right? Yeah. You need people. These are extremely complicated cases. Companies like, Google, Facebook have unlimited resources. And so you need to have enough officials to implement and enforce. Otherwise, you will have a beautiful piece of legislation, but it will not work. So at the end of the day, your regulation is only as good as its enforcement. And for successful enforcement, you need to have enough staff in the agency, and qualified staff, data scientists, engineers, economists, and lawyers.
Thank you, Damien. I'd like to turn to Soumya again now. Soumya, so in the last couple of years, there have been a number of competition cases against big tech firms like Apple, Amazon, Google for their abuse of dominant position, either at the CCI or at the other courts in India. What has your companies, what has Winzo's experience been with the legal process? Can you also maybe talk about some of the pitfalls within the legal system that you may have identified?
It's very, very aligned to what has been highlighted on this on this call. Sorry, on the session. Over the last 40 minutes is precisely what we had been experiencing, that unfortunately it takes time. Again, I'm amazed again how Sijo picked up a very pertinent point, that when you're off Play Store, then you have to go through a warning, which discourages users, because the end result of that warning is that 1 in 10 people who are looking to actually install actually end up installing, because that's really a very stalking warning, telling people that it can harm your device, it's a security breach, it's malicious, and thereby such a funnel drop really means cost, right? So we've actually tried going to the courts and getting relief, so that does not come in our way, because we are precisely paying 10x for what we need to otherwise pay only X, right? It's cost coming at the and hitting us in terms of rate of growth, etc., margins that the company is able to kind of generate for itself, and it takes time. So the process at times is longer than what you can wait for, and at times it can run into a couple of years, like it was highlighted much over the last 30 minutes, that at times you don't even if the relief you get, it's it's something which is difficult to execute really. At times that in the legal process itself, there's a behavior that you can see which causes intentional delay, and we've experienced all those things, and that experience comes at the cost of us paying exponentially to survive and sustain and grow in the market, which at times we feel that if there was something which was proactively done as guidelines, as guiding principles, what should not be done in the market to or what is identified as anti-competitive for this extremely fast moving digital world. Because believe me, since 2018 to 22 the gaming ecosystem looks very, very different. It's become India's become like one of the hottest markets, right? But we're still fighting the same battle on similar arenas. So that precisely means that we've like lost a lot of opportunity along the way in the last 3 or 4 years. So that's what from a business point of view we feel is something that if it were to be addressed in the law, then it would be very, very helpful, and it would get really practical and help players like us very early on. And of course, we are one of the evolved players because we have access to capital. We've raised in total of $100 million, but there are many, many young startups, many young professionals, who are unfortunately getting into the ecosystem with a passion to build, and building every single day, who may not even know the nuances of how to get around this entire process and what their actual rights are till they have a legal counsel, which is at a very evolved stage, right? So hence having guidelines, having guiding principles, etc., which are well defined, could be very, very helpful for organizations like ours and many other companies that are much younger.
Got it. And Rajneesh, the same question for you as well, right? What has KU's experience been with the legal process? And can you also talk about some of the pitfalls within the legal system that you at KU have recognized?
Yep. So I think at KU, we are fortunate not to have any ongoing litigation or having had to approach a court of law, though I know from previous examples and experience that it can be a much longer process. Though, as I said earlier, we do end up working within the App Store ecosystem, trying to decode what a particular interpretation or a policy means. Is it going to be amended 3 months from now? And then what is going to be the likely amendment, effect of the amendment of the Play Store policy? Are you in compliance, not in compliance? What is our interpretation of the Play Store policy, etc.? I think we go through those hoops, though they may not be within the legal system. But from a legal and business side, we keep going through those hoops from time to time, and actually it's quite often that am I in compliance or not, etc. I think from a, and this is going back to what Damian said, from a legal system perspective, there is probably a need to get out of our traditional mindset of saying, hey, this is a threshold, this is a micro marketplace, are you dominant in it or not, and start looking at some of these players as utilities, just as you would look at electricity, water, municipal waste, etc., etc. You should start looking at these entities as digital utilities who are important for the digital ecosystem to survive. I mean, there is no other raw material input or output apart from some whatever products these folks provide. So the lens to be changed is to call them a utility and add responsibilities as you would put on a utility. Can a utility compete with its own customer? The answer probably is no. Can a utility act in a manner that it dictates how one consumer of its services gets better serviced than the other? Then the answer is no. And we have to recognize the fact that these players have been around for a long time. They set the base for the ecosystem, so you cannot wish them away. Of course, they will be around, but treating them like utilities, treating them in a manner where they help the ecosystem grow rather than sort of suck money out of it or sit on $100 billion and so on and so forth. I think that's probably the way to go. The gatekeeper approach, the digital utility approach, and my general sense that in the Indian ecosystem, the Competition Commission of India, the recent the digital marketplace unit is probably best suited to sort of look at be a regulator for these utilities. Call them an electricity utility, call them a water utility, give them a role which is higher than others, put higher obligations upon them, put obligations of sanity and maintenance of the ecosystem. I think that's the way to interact with them. It works for everyone, them as well as other folks who are trying to grow up in the ecosystem.
Thank you so much for that, Rajneesh. Actually, that reminds me of something that I was going to ask Sijo next, in terms of having a competitor compete on the same platform for where it provides an infrastructure. And I'm sure, Sijo, this has been an issue with the Play Store too, because Google has its own apps on the Play Store, and you're essentially competing for eyeballs with those apps when it has control over how those eyeballs move, how much time they spend on each of these apps and the like. So what in your experience has been something that to put it very bluntly, something that prevents you from having the same kind of exposure to the platform, say like the infrastructure itself does? What do you think, for instance, if I were to draw a very raw parallel, what is it that you think advantages of Google Pay versus any other payment app that is competing on the same app store with the Google Pay? What is it that you think gives it that intermediation power, and what is it that you think must feature in our future discussions when we try and understand gatekeeper in India?
See, from the question there, right? So what taking a step back in terms of context, right? So the present competition laws, as Dr. Amarnath Patnaik also mentioned, was drafted in 2002.
Yeah.
And digital markets were not exactly even, sort of in existence or even sort of being very powerful. We started realizing the power of how mobile and app stores started shifting. That power shift happened somewhere in 2012, 2015.
Yeah.
And subsequently, even in India, it took a couple of more years when the geo revolution, everything happened, that the entire mobility shift has sort of happened, right? So it would be fair to say that this present framework has not even covered for a lot of behaviors that we could have observed in digital markets, right? On top of it, we are seeing instances where companies are actually, the Google Pay example that you mentioned, when these platforms themselves are operating in multiple markets of their own.
Yeah, exactly.
As Rajneesh pointed out, you're always thinking whether I'm working with a collaborator or a partner or a competitor, right? It's a very difficult position to be in. And the challenge is that all these summary of these policies eventually sort of keep pushing you towards the line of a vendor. In fact, one of the ways in which we could probably take offense with the developer agreement on the Google and App Store is the fact that it's almost as if it's a vendor agreement, right? If you start using their app, proprietary systems, you sort of actually lose agency over your own customers and sort of lose data of your own customers as well.
Yeah.
Right. And then you have actually seen shellocking or other forms of practices in which these companies come out with competing products as well. So from a directional perspective, I think a lot of discussions points that were raised in the forum, right, where companies beyond a particular threshold. And the reason why that is more required in digital markets is because of platform network effects and their ability to seamlessly move into other markets very quickly, right? Platforms work very differently. In such a scenario, what we are really talking about is how do we guide behavior?
Mm-hmm.
And that is what, if you look at burden proof, all these kinds of approaches, what we're looking at shaping is how do we sort of drive behavior? And some of these approaches makes a lot of, sense in terms of saying that a gatekeeper definition, whatever the threshold might be, we still have to probably debate what the threshold, the right threshold is in India. And anti-steering provisions. These are some of the elements that we have started seeing in these provisions across other legislative examples like Damien all pointed out. And in that one point Damien pointed out, right, I think I would want to probably double click on that one also. Damien did mention that the watchdogs also require people, right? So the capacity building is also very much a part of the whole system, right? Even if you look at an enforcement of a verdict, you need real-time monitoring, right? How do we equip some of these agencies or the industry itself to actually have real-time monitoring in terms of implementing or basically doing enforcement of the verdicts itself, right? These will require a significant amount of, let's say, rethink, not in just of capabilities, but also the paradigm. So let's say, is there proactive reporting to the regulator? We see that in financial markets and everything, right? So those are some of the directions we would probably want to look at it. And if I were to bring in one more element in terms of building on what Soumya conveyed. So another challenge a lot of companies face. So yes, Soumya did mention the fact that when they face an issue, they were not really aware of what kind of remedies we have or what are the ways to approach and start solving for it. We take legal counsel. One of the behaviors we start seeing is most of the prominent legal counsels in the country are already listed by some of these big tech firms as well. So the kind of, even if you want to fight, the kind of options that you have also is crowded out, right? So that is also another aspect which probably does not get surfaced in most of these discussions, which goes on to what Damien said, that the kind of resources that they have at disposal is very high. You have most of the major firms on retainers with some of these big tech firms. So the space for companies to operate is also very minimal. All the more reason why these behaviors being defined and making sure those behaviors are very clearly articulated and enforced is a great way. We will need to break off from some of the approach in the past. And even in UK, we have seen that they are looking at identifying certain companies, right? So instead of saying that the whole approach of dominance as a percentage market share, I think that is a foundation of shifting, right? Companies beyond a particular threshold, which has very strong dominant positions, which has the ability to distort markets, which has the ability to dictate terms in digital markets, they are being asked to perform to a higher standard of ethical and legal compliance and behavior, moral behavior and ethical behavior. And we are not even talking about new principles, right? We're talking about the same set of foundation principles of free and fair markets. It's just making sure that companies also abide by it so that everybody has a reasonable and fair chart of competing and winning on innovation and not on rent-seeking behaviors.
Thank you so much, Sijo. Soumya had to unfortunately drop off for another meeting, and I apologize, we have run over time. So I'll quickly wrap up with a final question to Rajneesh. So Rajneesh, we've talked a lot about the anti-competitive behaviors. In your opinion, what would be some of the practices of big tech that you would want to be listed as anti-competitive within the competition law itself?
Right. No, I think I wouldn't be able to name the very technical terms, but Sijo set them out, very, very well. I would largely, sort of, and I would request Sijo to say it out again. He probably has the right technical names for those. But I think at a larger theme scale, where they are able to suck more out of the market than they should, essentially because of their ability to, and I won't use the word dominate, but to be all pervasive. They are present, they have different arms and legs, and they're able to take things out of the system. So I'd let Sijo talk, just list out those 5 or 6 very specific terms, which I'm very sure he's much more conversant with.
So in terms of the terms, just to quickly respond to Janish, I also started learning up about these terms very recently. But one of the best things that, if I were to just add on to the experience of interacting with the parliamentary committee also, right? So one of the best takeaways of that, I'm also not a lawyer, so some of these technical terms are not exactly, to my understanding as well. So what the committee really asked us was also to say that, why don't you convey in terms of principles, right? And what are the specific ways you would like to see addressed? And it's when we start interacting with, let's say, people like Damien and others who are, at the forefront of some of the legislative reforms that we even looking at technical terms. But let's say anti-steering provisions broadly come into the mind in terms of, let's say, competing products being offered. Sherlocking is a behavior that we're seeing. So yes, there are certain terms out there, but broadly, a lot of those behaviors are getting, at least acknowledged and addressed in some of the legislative reforms. So there is understanding, and there are, at least now we have terms to classify those behaviors. That is a maturity in terms of understanding. Back to you, Manjushri.
Thank you so much. I think this has been a very fruitful discussion in terms of what all should one look out for, or what all one should hope for in terms of the shape that competition law and policy in India is going to take. And if anything, I think the panel has also stressed on the need to act quickly, because these are very, very fast moving markets, and every day lost is a huge opportunity cost, especially for stakeholders in the ecosystem. I mean, there is no restoring the market to the way it was. So any penalty or a fine will ultimately go into the pocket of a government agency that will be able to do something about it, but will not be able to sort of restore the market the way it was, perhaps. And who stands to lose from this is perhaps the competitors themselves. And given that we thrive ourselves on being a entrepreneur, startup oriented economy, and a country that prides itself on the level of innovation we have achieved in various fields, I think ensuring that there is a robust framework that keeps the spirit of entrepreneurship alive, keeps the spirit of free and fair competition for everyone alive is perhaps the need of this hour. And I'm hoping that Dr. Patnaik's remarks initially about the competition bill being tabled becomes a reality very soon, and we will hopefully be able to have many more fruitful discussions after that. Thank you, everyone, and over to you, Manath.
Thank you so much, Sijo, Damien, and Rajneesh, once again for taking out the time and for this very timely conversation and discussion. Thank you for joining us today, and thanks to the audience who joined us. A copy of this video will be available on our YouTube and our Twitter account at ADIF_India. Thank you so much.
Thanks a lot. Bye-bye.